So today we're going to dive into a pretty significant development in US immigration, one that could really change how the government evaluates some of the world's top talent. We're talking about the green card for people with extraordinary ability and a brand new court ruling that's putting the whole review process under a microscope.
All right, so here's our game plan. First, we'll get into what this unique green card category is all about. Then we'll break down the controversial two-step process they use to judge people. After that, we'll look at the big court case that's challenging the whole thing. And finally, we'll figure out what this means for applicants right now and what's coming down the road.
Okay, first things first, what exactly is this extraordinary ability category? It's often called the genius visa. Before we get into all the legal drama, we really need to understand who it's for and, how it's supposed to work. At its heart, the EB1A is for the absolute best of the best. It's a self-petitioned path, which is a really big deal. It means you don't need a US company to sponsor you. You can apply based completely on your own achievements. Think about that for a second. Your own merit gets you in the door. So when it comes to proving you're extraordinary, you basically have two options. Path number one is pretty simple, but it's incredibly rare. You win something huge, like a Nobel Prize or an Olympic medal. The second path, and this is the one most people take, involves showing proof that you meet at least 3 out of 10 very specific criteria. And here's where you get a feel for what that second path actually looks like. It's not about one single home run. It's about a whole collection of significant accomplishments. Things like winning important awards, being asked to judge your peers, or making a salary that puts you way at the top of your profession. This is the route most high achievers have to go. But meeting those criteria, that's just the start. The real controversy and really the heart of our whole story today is in how all that evidence gets judged. And that brings us to this thing called the two-step hurdle. This two-step process is what's causing all the fuss. First, the immigration officer just does a simple check. Did you submit enough proof for at least 3 of those 10 criteria? It's basically a box-checking exercise. If you pass, you move to step 2, the final merits determination. And this is where it all gets, complicated and very subjective. And this right here, this is the core of step 2. The officer takes a step back, looks at everything you've submitted, and then just makes a judgment call. It's not about checking boxes anymore. It's about them asking, okay, but does all this stuff taken together really prove this person is one of the very best? This super subjective standard is why so many people get denied and so frustrated. Just look at this chart. It really tells the whole story, doesn't it? A whole lot of people successfully pass that first step. They prove they meet the requirements on paper. But then, a really big chunk of them get denied at that second, subjective, final merits stage. And that's been a huge problem for a lot of incredibly qualified people. So all of this frustration, it had to go somewhere, right? And it did. It went straight to a federal court, which just issued a ruling that directly challenges the legality of this whole two-step system. This could honestly change the game for everyone. So get this, here's how it went down. An applicant met not just 3, but 5 of the 10 criteria. They passed step 1 with flying colors, but they still got denied at step 2, that subjective final look. Well, instead of just accepting it, they sued. They argued the process itself was illegal. And in a pretty stunning decision, the court actually agreed with them. The whole legal argument came down to this one law, the Administrative Procedure Act, or APA. Now, to put it simply, the APA says that government agencies have to play by fair, consistent, and predictable rules. The court basically said that this subjective final merit step was just an internal policy, not a formal rule that the public got to weigh in on. And because of that, it violates the APA's basic requirements for fairness. Okay, so a court made a ruling, but what does that actually mean for people applying right now? Or what about folks who were denied in the past? Let's break down what you can actually do with this information.
Let's get right to it. The million-dollar question. If you were denied because of this subjective review, does this mean your case is suddenly approved? And the answer, according to the experts, is a flat-out no. This court decision applies to the one specific case that went to court. It doesn't act like a magic wand and automatically overturn thousands of other past denials. But hold on, that no is not the end of the story, not by a long shot. While it doesn't automatically fix old cases, this ruling is now a powerful new tool in the toolkit. Applicants can now cite this case in their petitions. It gives you a really strong reason to challenge a request for more evidence, and it provides a solid foundation for anyone who was denied before to think about refiling their case, this time with a new legal precedent on their side. So where does this leave us? Well, this ruling kind of creates more questions than answers about the future of the whole system. The road ahead is, well, it's pretty uncertain. The immigration agency is now at a crossroads. They've basically got a few moves they can make. They could appeal the decision and hope a higher court sees it their way. They could try to make the two-step process into a formal official rule to get around the legal problem, or they might have to just scrap or seriously change the process altogether. And each of those choices has massive implications. So the bottom line here is we're in a watch and wait situation. This is not the final chapter. It might just be the opening shot in a much bigger debate over how the US actually defines and attracts the best talent. For now, everyone's just got to keep a close eye on what the agency does next. And all of this really boils down to one final huge question. Does this ruling mean we're starting to shift away from these subjective judgment calls and toward a more objective, evidence-based system? For the thousands of top scientists, artists, and innovators hoping to bring their talents here, the answer to that question could literally change everything.